Good morning, Your Honor.
Good morning. We're going to get started on DC 239494 Delta Victor LLC versus City of Lancaster. Counsel, make your appearances.
Good morning. I'm Liz Lamberson for the plaintiff, Delta Victor.
Chris Clement with the law firm of Fee, Smith and Sharp on behalf of defendant City of Lancaster.
All right, and there's a Mr. Valaire here. Is he on this case?
Yes.
Mr. Valaire is the principal of the plaintiff, Delta Victor.
Okay, great. I've read everything. Let's get started.
Well, Your Honor, the defendant city doesn't intend on presenting any witnesses here today. Really, we're discussing the face of the pleadings that plaintiff has provided, and there's a few points since the court has reviewed everything that defendant city wants to sort of focus on and direct the court's attention to. One, we'll start with the trespass argument. So one of the things that plaintiff respectfully does is misinterprets the Texas Tort Claims Act. So one of the arguments raised in the plea of the jurisdiction for the dismissal of plaintiff's trespass claim is the fact that it is an intentional tort, and intentional torts are barred under the Texas Tort Claims Act 101057. Plaintiff's argument in response to that is purely a legal one, and the legal argument is that is a misinterpretation of the code, in which plaintiff argues that 1010215 somehow waives all immunity and allows them to be sued and waives the protections of 101057 because the city is operating an airport. That's not exactly how the Texas Tort Claims Act works, as Your Honor is well aware. 1010215 of the Texas Tort Claims Act describes what governmental functions are. So generally describes what sort of activities a city could engage in which the Texas Tort Claim Act creates some sort of waiver of immunity. However, that is not a total waiver of immunity, and the Tort Claims Act goes on to describe more specifically what causes of actions can be brought. So, for example, 101021 would talk about operation of a motor vehicle or use of personal property. You have other parts of the Tort Claims Act that talk about premises defects, things along those lines. However, 101057 expressly states that the cities are protected, that there is no waiver of immunity if there is an intentional tort claim that is brought against them. Here, a trespass is undeniably an intentional tort. The fact that plaintiff is bringing this as a takings claim, which causes or requires an intentional act, further sort of shows that yes, this trespass is an intentional tort. Because that is the case, the Texas Tort Claims Act expressly protects and prohibits any sort of suit or liability for an intentional tort claim. So for that reason,
Are there any cases on point that talk about takings or trespass?
with well, so
Give me,
are you?
I'm sorry, just give me 1 second. I apologize.
Sure.
All right, go ahead.
Yes, Your Honor. So first, just to make sure that the argument that's being presented is clear, we're not intending to use the Tort Claims Act to say that there is no waiver, that they can't bring their takings claim.
Okay.
Here, we're specifically bringing up that the express language of the Tort Claims Act under 101057 establishes that you do not have a waiver. There is a prohibition of claims if they fall under intentional tort. So, for example, 101057 expressly states this chapter does not apply to a claim. And 2 says arising out of assault, battery, false imprisonment, and then importantly, or any other intentional tort. So,
I was asking, are there any cases that have applied that to trespass?
yes, Your Honor, there have. Let me pull one. I've got one here to pull up for you. So just a quick, the city of Lake Austin versus Attaway, which is in the First Court of Appeals, decided May 23rd, 2023. In footnote 7 states, the property owner's pleadings are not clear as to whether they alleged intentional or negligent nuisance or trespass. We presume they intended to allege negligent nuisance and trespass here because the act does not waive immunity for intentional torts. And the property owner's intentional nuisance and trespass claims fall within the waiver of immunity under the Article 1, Section 17 of the Texas Constitution.
Ms. Lamberson, are you still pursuing a trespass claim? It does seem to be, it is an intentional tort.
I believe Texas recognizes a cause of action for negligent trespass. To the extent that our pleadings aren't clear, I think I can clean that up and plead in the alternative as far as the takings versus the trespass claim.
Your Honor, may I respond?
So I don't know that there's a distinction. I thought trespass had to be intentional, but to the extent that I will grant the plea of the jurisdiction to the extent that they're asserting intentional trespass.
Thank you, Your Honor. And just a quick note that I'll have on the distinction between whether they can bring a negligent trespass claim. Their cause of action here largely is alleging that there is a takings. The conduct that they're alleging, as you well know, you can't have a negligent takings. So if they're claiming that the city's actions were intentional in nature with regard to the takings claim, I don't see how they can also bring a negligent trespass claim for the same course of conduct. But moving on from that to the takings claim. So, Your Honor, for the takings claim, the legal distinction here for the court to decide is whether the 10-year statute of limitations or the 2-year statute of limitations applies in this case. And the question there is, do we have a permanent physical invasion of the property or do we have damage to the property? So in this case, what we have, and as briefed out for the court, is even in plaintiff's response, acknowledging that if there is just damage, if it's not a permanent physical invasion, then you have the 2-year statute of limitation. The 10-year statute of limitation only comes into play for a trespass claim if it amounts to that full physical invasion because it's likened to an adverse possession type of situation. So if we're looking at the plaintiff's pleadings alone, which again, the city has not provided any additional exhibits. We're challenging the face of the pleadings alone. Plaintiffs also haven't provided any additional evidence or documentation with their written response. If you look to page 4 of plaintiff's second amended petition, which is the live petition, at the top of page 4, at the very end of paragraph 11, it talks about the city's actions have caused and continues to cause significant damage and erosion to the remainder. The drainage has caused a large and growing ditch to form on the remainder. Again, at the end of paragraph 12, it discusses caused and continues to cause significant damage and erosion on the property. Paragraph 13 states significant remediation will be required in order to return the remainder to its original condition. And it describes the need for the city to cease allowing the runoff described herein. It also refers to Exhibit D of their complaint or of their petition. And if we look at Exhibit D shows their alleged damage, which is water runoff onto the property. So a few key facts. One, plaintiffs do not allege that there is any sort of the city has not built anything on their property. The city has not entered onto their property. The only thing that they're alleging here is that there is water that is run off onto the property and that it's causing erosion and it's causing a ditch. That's damage. That is, you know, what they're alleging. You know, the city's not conceding that it's damaged their property, but based on their allegations, as we must hear for the plea to jurisdiction, they're alleging that damage has been done to their property by the city. When you're talking about a takings claim, you're talking about a removal of all rights, right? You know, a case that plaintiff cites to with regard to the sort of physical invasion had to do with laying pipe on the property, had to do with laying, you know, communication lines, things along those lines, where the city has or a municipal district has physically entered the property, has laid things down, and has total and exclusive control over part of the property. We don't have that here. What we have is tantamount to sort of a nuisance situation where actions that occurred by the city entirely on its own property without the city entering onto the plaintiff's property is causing some damage to the plaintiff's property. At that extent, it doesn't completely remove rights of the plaintiff. Plaintiff still has total control over its own property, still has total use of its own property. There's nothing that the city is doing that would completely prohibit, and I'm talking about from a right standpoint, plaintiff having the right to use its property the way that it wants to. Instead, we just have alleged damage to the property from water runoff. For that reason, and based on the factual situation here in the case, much of which is conceded by the plaintiff, that's a 2-year statute of limitations. And per plaintiff's own response, this condition was created in 2015. And I would direct the court's attention to page 7 of plaintiff's response to defendant's third plea to the jurisdiction, which states, it appears that the construction causing the condition occurred in 2015. So with that being the case, that would be well outside the 2-year statute of limitations for plaintiff in this case. Moving on to the breach of contract claim, again, the inciting incident is this 2015 expansion of the airport, which caused additional water runoff. As the court is aware, breach of contract statute of limitations runs for a 4-year period as opposed to just a 2-year period. But even if that was the case, this occurred back in 2015. This isn't something that occurred within 4 years of the filing of this lawsuit. Now, to sort of circumvent that, plaintiff alleges that there's some sort of continual obligation under the contract and cites to an unreported case that's not binding on this court, discussing the fact that, oh, there was this continual obligation for a covenant. Well, here we don't have, you know, when we're talking about this inciting incident in 2015, it's a specific act. It is the city's intentional expansion of the airport and the resulting water runoff increase that occurred because of that, as plaintiff alleges. So we're talking about a singular act here that the city allegedly engaged in that caused this additional water runoff. We're not talking about a continual failure. We're talking about a singular incident here, as plaintiff discusses in their response. The only other thing that the plaintiff discusses in its pleadings is it generally states that the city has failed to maintain easements.
Was there a settlement agreement that was entered?
Yes, Your Honor. Well, that's a disputed fact. I would say whether or not it was a settlement agreement, there was a purchase of property that was made in lieu of, well, prior to there being some sort of perhaps condemnation, eminent domain, you know, situation where the city was building the airport. However, if the court wants to consider that to be a settlement agreement, that occurred back in 1984. The specific breach, and the reason I'm talking about the continuing easements, things along those lines, is that other than generally stating that the city has not maintained the easements, the only specific act that the defendants discuss is this 2015 expansion of the airport. And as the court is aware, conclusory statements are insufficient to give rise to jurisdiction, especially when there's a jurisdictional challenge like we have here in this case. So looking just at the face of the pleadings and plaintiff's judicial admissions in their response, the issue, the condition that they're complaining of occurred in 2015. And so with that being the case, that is well outside the 4-year statute of limitations when they brought the instant cause of action. And so for these reasons, the defendant city asked the court to grant its plea to the jurisdiction and dismiss plaintiff's trespass, breach of contract, and takings claim.
All right. The response?
Yes, Your Honor. I'm going to take those in reverse order, if that's okay. On the breach of contract, the case that Mr. Clement is referring to is location limited versus Home Depot. He's correct that it is an unpublished opinion from Amarillo, which is not binding on this court. However, there's no, there's a lack of authority out of the Dallas court for this court to look to. In that case, location, and Home Depot owned adjoining pieces of property. They entered into a series of agreements wherein Home Depot agreed that if it placed a sign within 50 feet of the road, it would do so in a way that that sign would not block location's billboard. In 2006, Home Depot put a sign up that blocked the billboard. Location did not sue until 2019. So of course the limitations came into play. The Amarillo Court of Appeals found that the parties had entered into an agreement governing the usage of their adjoining commercial property that contained continuing covenants and promises. And for that reason, location could recover for its damages that occurred within 4 years prior to filing the lawsuit, just like with an installment contract. Like this case, there was a single event that caused the breach. It was the placement of the sign. There's no reason to distinguish this case from that case in that regard. In 2015, the city constructed the various structures that have caused the flooding. In that case, it was 2006 when they placed a sign. Both are construction. And again, understanding it's not a binding on this court, it's still almost identical factually, and I think the court should take it into consideration. As far as the takings claim, to describe for the court what we're talking about, the water comes off of the airport and flows into a channel that has been eroded into Delta Victor's property. The channel cuts at an angle, not exactly in the middle, but close to the center of the property. I mean, it's true that it is damaged, but it's damaged to such a level that it renders Delta Victor's property useless. Essentially, Delta Victor's property has become the holding tank drainage area for its airport. Delta Victor could go out and fill up this ditch, do whatever it needs to do to stabilize the property, and then build something on it. But over time, the water would continue to flow in the same direction and erode that land again and flow against the foundation of anything that were built. And as a result, Delta Victor is prohibited from using its property as it would if it were not a drainage ditch for the city. And that's what makes it rise to the level of a taking.
Okay. And then what about trespass?
Again, Your Honor, I could clean up my pleadings to show that we're pleading in the alternative as a negligent trespass. It's either an intentional taking or a negligent trespass, and that would be a strictly alternative pleading.
Okay. All righty. The court is going to grant the plea to the jurisdiction on the issue of intentional trespass. It's going to deny the remainder. and I will go ahead and you don't need to submit a new order. I've kind of marked up the order you submitted. So,
Your Honor, I'm sorry, I don't mean to interrupt.
okay, yeah, sure. So,
Well, just quickly with regard to the court's order, if I'm hearing plaintiff in their argument with regard to their breach of contract claim, it would limit the damages for which they could recover to damages within 4 years of filing the lawsuit or the previous 4 years.
right, I agree
With
with
regard
that.
to her argument under location. Defendant City would ask that there be some sort of something reflecting in the order or some sort of limitation that with regard to the breach of contract claim, only those four years prior to the lawsuit being filed would be considered for damages under that claim.
I agree with you. I think that's appropriate. I just don't know plea to the jurisdiction. I've always understood pleas to jurisdiction deal with particular causes of action, and so that's a limitation. That's something you can bring up at the time of the charge conference if we get that far. But you have this on the record. I agree with your understanding, and you can quote me at the time of the charge conference. Okay.
Always good to be able to quote the judge.
All right. You guys have a good briefing on both sides. You guys have a great rest of your day. Okay.
Thank you, Your Honor.
Thank you very much. May we be excused?
You may. All right. Are both sides here for the summary judgment?
No, Your Honor. A response was not filed by the respondent. And Randall Telford, the third-party attorney for Title Resource Guarantee Company, he in fact told me I could announce that he does not plan to attend this hearing as he has no stake in the results, but he will be filing a dismissal document after this hearing.
Okay. This is set for 10 o'clock. So I doubt the respondent will show up. But while we're here, why don't I just make sure I'm looking at the right order, because there's a few orders here.
Yes, Your Honor.
So what order are you asking me to sign?
So on the court today, we have two different hearings. One is on the second partial interlocutory motion for summary judgment versus only Lucio Morales. So we would ask the court to sign, if that's granted, the interlocutory and partial summary judgment for CRL against Lucio Morales. Then the next thing is...
Wait.
Yes, Your Honor.
Can you look at the screen real quick?
Yes.
Which orders do you want me to potentially sign here?
Well, there's three. The first one would be, at least that's listed, it shows proposed order judgment against all. That would be the final one. After we have the hearings on the others if they're granted.
Okay.
But they seem to be a little out of order. There is a proposed interlocutory offensive summary judgment. That's the first one that I was just referring to.
Okay.
Then there will be the proposed interlocutory final default judgment against the other two defendants, where we already have a default judgment on liability, and this is seeking on damages.
Okay.
And then that we would have, if those are both granted, then I filed a motion and a proposed final judgment against all, which would dispose of all the claims.
That's not set for today. This one's not set for today, right?
Well, if the court wants to entertain a final judgment, seeing that everything else it would be entered. I thought you told me there was another party that needs the non-suit or something. That was what I understood. Well, he has said that I can advise the court that we already have an agreement between the two of us, as the only issue that the court would otherwise need to determine is what happens to excess surplus proceeds from the foreclosure sale. And what I'm saying in my other motions is that these other defendants have no claim to them whatsoever. So it would only be left between Texas, the third-party intervener, Texas Guarantee Resources Company, and CRL, my client. And they have an agreement as to how to split them. So if Your Honor wants to hold the final judgment, but the final judgment that is proposed is against the other parties, plaintiff and third-party defendants.
I don't have a strong opinion. I want to only rule on what's set for today. That's
all right. All right. Thank you, Your Honor. And sometimes a judge will just want one final judgment, wrapping it all together. But I wanted to do it piecemeal in case, because I didn't know which way the hearing was going to go necessarily.
Okay.
It's an all or nothing versus pieces. I know there's a lot of parts to this. So if Your Honor wants to wait, maybe and by submission, rule on the entry of final judgment if the court grants the summary judgment motion and the motion for entry of default judgment, because then there's really no other issues to be determined except for the one that we're taking off the table, which is that we have an agreement as to the proceeds with TRGC. And he, like I said, Your Honor, he authorized me, Randall Telford authorized me to advise the court of that. And that's why he's not even showing up for the hearing.
Okay, we'll just submit an agreed motion on that then. All right.
That's on file.
An agreed motion?
My entry for final judgment, and then Mr. Telford will be filing after the hearing his own dismissal of any remaining claims.
Okay.
But if Your Honor wants to wait for that, then
yeah, I
okay.
can with that.
All right.
There's two other people here, T-Bar and Al. What are you guys here for? I don't have anything else set.
Your Honor, I'm here on the Chase Bank summary judgment motion.
Your Honor, I'm here on your 10 o'clock.
The Morales versus CR lending case?
Yes, Your Honor, really more in a observatory capacity than anything else.
Okay.
And I'm also here observing, Your Honor, the Chase Bank versus David Rose case.
That one's not set anymore. I'm not sure.
Well, the primary counsel never notified me, Judge, but I'll leave your.
What's the name of the case again?
It's Chase Bank, but that's not the official name, if you'll bear with me. It's versus David Rose. And
there's nothing set today, sorry.
I was notified they had a summary judgment motion set today, Your Honor.
Yeah, it was canceled by Diana Jimenez. I'm not sure who that is, but
okay. Well, I need to make sure that she knows that I represent the cross defendant on the case.
Okay.
And I'll contact them to make sure they notify me from now on.
What is going on with this case? It's not set for trial. It looks like it needs to be set for trial.
Your Honor, I'm not quite sure since I'm not getting notifications from the primary attorneys. Excuse me. I can't really speak to that. As I said, I represent one of the cross defendants, and we were brought in by David Rose, one of the defendant.
Okay.
And I'll contact them and let them know they need to get on the ball.
No problem. You have a great rest of your day.
Thank you, Judge. You too.
All right, Tony, it's 10 o'clock. Let's go on the record. On DC 237361, counsel, make your appearance.
Bennett M. Wise on behalf of Movement CR Lending LLC.
Yes, Tom Barron on behalf of the defendants, Your Honor, or at least, excuse me, on behalf of Mr. Morales, Lucio Morales.
Okay. He's the plaintiff, right?
Well, initially, and the counter defendant, I believe maybe even cross defendant as well.
All right. You may proceed.
Thank you, Your Honor. May it please the court. So just summing
Your
up.
Honor, if I may, to short circuit Mr. Wise, and I don't mean to interrupt, there's just no real reason to do that. We have not filed a response. My client is well aware of that. There's no reason to waste Mr. Wise's time, and certainly not the court's time.
So we were talking before you got on. Have you seen the three? Let me just do this, Mr. Brand. This will be the simplest way to do this. I'm going to share screen with each of the orders that he's proposed. You tell me if you oppose the entry of this order. Any opposition to the entry of this order? Mr. Barron? We can't hear you, Mr. Barron. Can you hear me?
I'm still looking, Judge. I'm so sorry. I'm trying to read it, and I'm having a tough time.
It's the
'Cause it's
proposed
small.
summary judgment.
Your Honor, I don't have any problems with the form.
Okay. I will sign this order on the offensive.
Your Honor, I'm sorry. I take that back, and I apologize. There's no election of remedies in this. It says for civil, it says breach of contract, civil fraud, and civil conspiracy. I think that he needs to elect his remedy either as breach of contract or fraud. Because I believe the damages as pled were the same, were they not?
The damages pled are just for accumulated attorney's fees.
The 36,000?
That's right. And I filed a lodestar, very long attorney fee affidavit.
Yeah, I did see that, but I was looking down at the other, and again, I'm having a tough time reading this, and so don't. Again, Judge, if it's for fraud, civil fraud, obviously he's not going to be able to get his attorney's fees for that. I'm trying to figure out at this point, you've got $36,000 in attorney's fees. Are those actual damages or are those attorney's fees?
Well, they're the damages that are incurred. We're not asking for a finding of tort damages separately from the attorney's fees for civil fraud, civil conspiracy. Thought it was actually giving your clients a break by merely going for what was actually damages, provable damages for attorney's fees for this long protracted case that should have never been brought.
But you don't get attorney's fees for civil fraud or civil conspiracy. Those are tort claims.
Okay, what paragraph are you complaining about?
The first full paragraph on the last page, Judge.
All right, so what part do you complain about?
My concern, Judge, is that these are the monetary damages that he's talking about aren't damages at all. They're attorney's fees. One, you don't get attorney's fees for civil fraud or civil conspiracy. That's a tort claim. They're tort claims. Breach contract, Judge, you have to have actual damages in order to get attorney's fees. Actual damages aren't the attorney's fees. This is not a claim, for example, for malicious civil prosecution, where those damages would in fact be recoverable.
This is also a claim for declaratory judgment.
But again, Judge, if it's a claim for declaratory judgment, I don't see the declaration here where that's, I mean, again, that doesn't help us because he's saying these are monetary damages and they're not, they're attorney's fees.
So how do you want me to change this order then?
Judge, I don't know that you can. I think that he bottled himself up by putting the damages in, or putting the attorney's fees in where the damages are.
Well, we're not claiming any other damages besides having to defend the lawsuit and the cost it took to do that.
But they don't have a claim for that, Judge.
it was always pled in the other pleadings in motion. There was no response filed to that.
Judge, be that as it may, that doesn't make it recoverable.
Well, under other and further relief, we would ask the court to grant $1.
Which that's not proved up in his pleadings.
I mean, did
You
you
try again in another summary judgment, or he can amend this one. But
so on this summary judgment, did you assert a claim under the Declaratory Judgment Act?
Yes, Your Honor.
Because it's not in the order.
Well, it covers, we already have, it covers who gets the proceeds. That was answering the declaratory judgment.
Okay, but I'm just, let me see.
In the
So,
in the summary judgment motion.
I guess this talks about it could be declared. Okay.
On page 5 of the motion under section E1. It is a bookmarked motion, Your Honor.
Okay, I'm just looking at the order right now. Yeah, I don't know that you can get. Okay, this is I see your issue, Mr. Barrett. I'm trying to. Let's see. I don't see how you get attorney's fees for fraud, conspiracy, or breach of contract. I could see it for declaratory judgment.
We would be fine with that, just to close this out.
All right. Some issues here. Let me see. Okay, let's look at the next order. That's not it.
That's the proposed final default judgment against Karen Morales and Guadalupe Ann Morales.
Okay, there's a proposed interlocutory final judgment against Karen Morales. Okay. And you don't represent these people, right?
no, Your Honor.
There's already an interlocutory default judgment against them as
Against
to
them, yeah.
liability. And no answer was ever filed. There was a motion to set aside the judgment. That was denied.
All right, so let's go to the next thing. So there's a final order. What is your position on this final order he submitted?
Your Honor, I think that I pointed out what I believe the problems were in the prior order, and I think that probably covers this as well. But I'm looking at Your Honor, I'm looking at his summary judgment. And I'm looking at specifically the declaratory judgment action, and I don't see a request for attorney's fees there. And certainly, even if there were, they're not damages, they're attorney's fees. And again, it has to be tied to something unless you have a specific cause of action that allows for the recovery of attorney's fees as damages, such as a malicious civil prosecution case. I don't see that here.
But he can recover attorney's fees under declaratory judgment action, even without the award of damages, if they're equitable and just. And so,
but he doesn't ask for them in the summary judgment.
All right, then you're right. Then this isn't appropriate. So what do you want to do at this point? Do you want to?
Well, it sounds like I have to go back to the drawing board on another motion for summary judgment. And this, we were hoping to get this disposed of today because it's set for judgment for trial, I believe December 17th. The court had reset that to give time for this hearing today.
Your Honor, I don't have a problem with pushing this out a month or so he can get a summary judgment filed. I don't have a problem with that. I don't want to be difficult.
I'm not going to do that. So you guys get it worked out, okay?
Yes, Your Honor. Thank you.
You have a great rest of your day.
You as well.
And Your Honor, as far as the default judgment against the other two defendants?
Yeah, I already signed that and sent it to the clerks.
Okay, so that one is done. And so I will inform Mr. Telford, and then I'll get back to the court for proposed final judgment or something else.
Yeah, proposed order or something.
Yes.
All right, you guys have a great rest of your day.
Thank you.
You as well, Judge. Thank you.
Bye-bye.